In law, a contract is an agreement having a lawful object entered into voluntarily by two or more parties, each of whom intends to create one or more legal obligations between them. The elements of a contract are offer and acceptance by competent persons having legal capacity who exchange consideration to create mutuality of obligation. Proof of some or all of these elements may be done in writing, though contracts may be made entirely orally or by conduct. The remedy for breach of contract can be damages, in the form of compensation of money or specific performance enforced through an injunction. Both of these remedies award the party at loss the benefit of the bargain, or expectation damages, which are greater than mere reliance damages, as in promissory estoppel. The parties are maybe natural persons or juristic persons. A contract is a legally enforceable promise or undertaking that something will or will not occur. The word promise can be used as a legal synonym for contract, although care is required as a promise may not have the full standing of a contract, as when it is an agreement without consideration. Contract law varies greatly from one jurisdiction to another, including differences in common law compared to civil law. The impact of received law, particularly from England in common law countries, and of law codified in regional legislation. Regarding Australian contract law, for example, there are 40 relevant acts which impact on the interpretation of contract at the Commonwealth level, and an additional 26 acts at the level of the state of NSW. In addition, there are several international instruments or conventions which are applicable for international dealings, such as the United Nations Convention on Contracts for the International Sale of Goods. History. Contract law is based on the principle expressed in the Latin phrase pacta sunt servanda, which is usually translated, agreements must be kept, but more literally means, pacts must be kept. Contract law can be classified, as is habitual in civil law systems, as part of a general law of obligations, along with tort, unjust enrichment, and restitution. The common law of contract originated with the writ of assumpsit, which was originally a tort action based on reliance. Jurisdictions vary in the principles of freedom of contract. In common law jurisdictions such as England and Wales in the United States, a high degree of freedom is expected. For example, in American law, it was determined in the 1901 case of Hurley v. Eddingfield that a physician was permitted to deny treatment to a patient despite the lack of other available medical assistance and the patient's subsequent death. This is in contrast to civil law, which typically applies certain overarching principles to disputes arising out of contract, as in the French Civil Code. Other legal systems such as Islamic law, socialist legal systems, and customary law have their own variations. However, in the case of the United States, the principle of freedom of contract has eroded over time due to judicial deference to legislation affecting contracts. For example, the Civil Rights Act of 1964 restricted private racial discrimination against African Americans. In the early 20th century, the United States underwent the Lochner era, in which the Supreme Court of the United States struck down economic regulations on the basis of freedom of contract and the Due Process Clause. These decisions were eventually overturned and the Supreme Court established a deference to legislative statutes and regulations which restrict freedom of contract. The U.S. Constitution contains a contract clause, but this has been interpreted as only restricting the retroactive impairment of contracts. Not all agreements are necessarily contractual, as the parties generally must have an intention to be legally bound. In American English, a gentleman's agreement is one which is not intended to be legally enforceable. The equivalent concept can be expressed in agreement, binding in honor only. Commercial use contracts are widely used in commercial law, and form the legal foundation for transactions across the world. Common examples include construction contracts, product purchases, software licenses, employment contracts, insurance policies, real estate deeds to transfer title, professional services, wholesale merchandise supply, and various other uses. Online contracts have become common. E-signature laws have made the electronic contract and signature as legally valid as a paper contract. It has been estimated that roughly 110 electronic contracts are signed every second. From a legal point of view, in India, e-contracts are governed by the Indian Contract Act, according to which certain conditions need to be fulfilled while formulating a valid contract. Certain sections in Information Technology Act also provide for validity of online contract elements. At common law, the elements of a contract are offer, acceptance, intention to create legal relations, and consideration. Offer and acceptance. In order for a contract to be formed, the parties must reach mutual assent. This is typically reached through offer and an acceptance which does not vary the offer's terms, which is known as the mirror image rule. If a purported acceptance does vary the terms of an offer, it is not an acceptance but a counteroffer and, therefore, simultaneously a rejection of the original offer. The Uniform Commercial Code disposes of the mirror image rule in 2-207, although the UCC only governs transactions in goods in the USA. As a court cannot read minds, the intent of the parties is interpreted objectively from the perspective of a reasonable person. As determined in the early English case of Smith v. Hughes, 1871, contracts may be bilateral or unilateral. A bilateral contract is an agreement in which each of the parties to the contract makes a promise or set of promises to each other. For example, in a contract for the sale of a home, the buyer promises to pay the seller $200,000 in exchange for the seller's promise to deliver title to the property. These common contracts take place in the daily flow of commerce transactions, and in cases with sophisticated or expensive promises may involve extensive negotiation and various condition precedent requirements, which are requirements that must be met for the contract to be fulfilled. Less common are unilateral contracts in which one party makes a promise but the other side does not promise anything. In these cases, those accepting the offer are not required to communicate their acceptance to the offerer. In a reward contract, for example, a person who has lost a dog could promise a reward if the dog is found, through publication or orally. The payment could be additionally conditioned on the dog being returned alive. Those who learn of the reward are not required to search for the dog, but if someone finds the dog and delivers it, the promisor is required to pay. In the similar case of advertisements of deals or bargains, a general rule is that these are not contractual offers but merely an invitation to treat. But the applicability of this rule is disputed and contains various exceptions. The High Court of Australia stated that the term unilateral contract is unscientific and misleading. In certain circumstances, an implied contract may be created. A contract is implied in fact if the circumstances imply that parties have reached an agreement even though they have not done so expressly. For example, a patient may implicitly enter a contract by visiting a doctor and being examined. If the patient refuses to pay after being examined, the patient has breached a contract implied in fact. A contract which is implied in law is also called a quasi-contract, because it is not in fact a contract, rather, it is a means for the courts to remedy situations in which one party would be unjustly enriched were he or she not required to compensate the other. Quantum meruit claims are an example. Intention to be legally bound in commercial agreements. It is presumed that parties intend to be legally bound unless the parties expressly state the opposite as in a heads of agreement document. For example, in Rose and Franco v. Junior Crompton and Brothers Limited, an agreement between two business parties was not enforced because it contained an honor clause, which stated the parties wished that the agreement not be reviewed or enforced by a court. In contrast, domestic and social agreements such as those between children and parents are typically unenforceable on the basis of public policy. For example, in the English case Balfour v. Balfour, a husband agreed to give his wife £30 a month while he was away from home, but the court refused to enforce the agreement when the husband stopped paying. In contrast, in Merritt v. Merritt, the court enforced an agreement between an estranged couple. Consideration. Consideration is something of value given by a promisor to a promisee in exchange for something of value given by a promisee to a promisor. Typically, the thing of value is a payment, although it may be an act, or forbearance to act, when one is privileged to do so, such as an adult refraining from smoking. This thing of value or forbearance from some legal right is considered to be a legal detriment. In the exchange of legal detriments, a bargain is created. In the United States, the emphasis has shifted to the process of bargaining as exemplified by Hammer v. Sidway. Roman law-based systems do not require consideration, and some commentators have suggested that consideration be abandoned, and estoppel be used to replace it as a basis for contracts. However, legislation, rather than judicial development, has been touted as the only way to remove this entrenched common law doctrine. Lord Justice Denning famously stated that, "The doctrine of consideration is too firmly fixed to be overthrown by a side wind." Courts will typically not weigh the adequacy of consideration as long as the consideration is determined to be sufficient, with sufficiency defined as meeting the test of law, whereas adequacy is the subjective fairness or equivalence. For instance, agreeing to sell a car for a penny may constitute a binding contract if a party desires the penny. This is known as the peppercorn rule, but in some jurisdictions, the penny may constitute legally insufficient nominal consideration. Parties may do this for tax purposes, attempting to disguise gift transactions as contracts. Transferring money may be sufficient, particularly if there is accord and satisfaction. However, consideration must be given as part of entering the contract, not prior as in past consideration. For example, in the early English case of Eastwood v. Kenyon, 1840, the guardian of a young girl took out a loan to educate her. After she was married, her husband promised to pay the debt, but the loan was determined to be past consideration. The insufficiency of past consideration is related to the pre-existing duty rule. In the early English case of Stilk v. Myrick, 1809, a captain promised to divide the wages of 2 deserters among the remaining crew if they agreed to sail home short-handed. However, this promise was found unenforceable as the crew were already contracted to sail the ship. The pre-existing duty rule also extends to general legal duties. For example, a promise to refrain from committing a tort or crime is not sufficient. Formation. In addition to the elements of a contract, a party must have capacity to contract. That means parties in a contract must justify their majority in age to understand terms of the contract and be mentally able. The purpose of the contract must be lawful. The form of the contract must be legal. The parties must intend to create a legal relationship. The parties must consent. As a result, there are a variety of affirmative defenses that a party may assert to avoid their obligation. Affirmative defenses vitiating factors constituting defenses to purported contract formation include mistake, incapacity, including mental incompetence and infancy, minority, duress, undue influence, unconscionability, misrepresentation or fraud, frustration of purpose. Such defenses operate to determine whether a purported contract is either void or voidable. Void contracts cannot be ratified by either party. Voidable contracts can be ratified. In the United States, persons under 18 are typically minor and their contracts are considered voidable. However, if the minor voids the contract, benefits received by the minor must be returned. The minor can enforce breaches of contract by an adult, while the adult's enforcement may be more limited under the bargain principle. Promissory estoppel or unjust enrichment may be available, but generally are not. formalities and writing. Typically, contracts are oral or written, but written contracts have typically been preferred in common law legal systems. In 1677, England passed the Statute of Frauds, which influenced similar statute of frauds laws in the United States and other countries such as Australia. In general, the Uniform Commercial Code as adopted in the United States requires a written contract for tangible product sales in excess of $500, and real estate contracts are required to be written. If the contract is not required by law to be written, an oral contract is valid and therefore legally binding. The United Kingdom has since replaced the original Statute of Frauds, but written contracts are still required for various circumstances such as land. An oral contract may also be called a parole contract or a verbal contract, with verbal meaning spoken rather than in words. An established usage in British English with regards to contracts and agreements, and common although somewhat deprecated as loose in American English. If a contract is in a written form, and somebody signs it, then the signer is typically bound by its terms regardless of whether they have actually read it, provided the document is contractual in nature. However, affirmative defenses such as duress or unconscionability may enable the signer to avoid the obligation. Further, reasonable notice of a contract's terms must be given to the other party prior to their entry into the contract. An unwritten, unspoken contract, also known as a contract implied by the acts of the parties, which can be either an implied-in-fact contract or implied-in-law contract, may also be legally binding. Implied-in-fact contracts are real contracts under which the parties receive the benefit of the bargain. However, contracts implied in law are also known as quasi-contracts, and the remedy is quantum meruit, the fair market value of goods or services rendered. Invitation to treat, where a product in large quantities is advertised in a newspaper or on a poster. It generally is not considered an offer but instead will be regarded as an invitation to treat, since there is no guarantee that the store can provide the item for everyone who might want one. However, an exception to this rule may be made if an advertisement includes a reward, which is what happened in the famous case of Carlisle v. Carbolic Smokeball Company, decided in 19th century England. In Carlisle, a medical firm advertised a smoke ball marketed as a wonder drug that would, according to the instructions, protect users from catching the flu. If it did not work, buyers would receive £100, and the company said that they had deposited £1,000 in the bank to show their good faith. When sued, Carbolic argued the ad was not to be taken as a serious, legally binding offer. It was merely an invitation to treat, and a gimmick. But the Court of Appeal held that it would appear to a reasonable man that Carbolic had made a serious offer, and determined that the reward was a contractual promise. Third parties. The doctrine of privity of contract means that only those involved in striking a bargain would have standing to enforce it. In general, this is still the case. Only parties to a contract may sue for the breach of a contract, although in recent years the rule of privity has eroded somewhat and third-party beneficiaries have been allowed to recover damages for breaches of contracts they were not party to. In cases where facts involve third-party beneficiaries or debtors to the original contracting party have been allowed to be considered parties for purposes of enforcement of the contract. A recent advance has been seen in the case law as well as statutory recognition to the dilution of the doctrine of privity of contract. The recent tests applied by courts have been the test of benefit and the duty-owed test. The duty-owed test looks to see if the third party was agreeing to pay a debt for the original party, and whereas the benefit test looks to see if circumstances indicate that the promisee intends to give the beneficiary the benefit of the promised performance. Any defense allowed to parties of the original contract extend to third-party beneficiaries. A recent example is the UK's Contracts Act 1999. Performance varies according to the particular circumstances. While a contract is being performed, it is called an executory contract, and when it is completed it is an executed contract. In some cases there may be substantial performance but not complete performance, which allows the performing party to be partially compensated. Uncertainty, incompleteness and severance. If the terms of the contract are uncertain or incomplete, the parties cannot have reached an agreement in the eyes of the law. An agreement to agree does not constitute a contract, and an inability to agree on key issues, which may include such things as price or safety, may cause the entire contract to fail. However, a court will attempt to give effect to commercial contracts where possible, by construing a reasonable construction of the contract. Courts may also look to external standards, which are either mentioned explicitly in the contract or implied by common practice in a certain field. In addition, the court may also imply a term. If price is excluded, the court may imply a reasonable price, with the exception of land and second-hand goods, which are unique. If there are uncertain or incomplete clauses in the contract, and all options in resolving its true meaning have failed, it may be possible to sever and void just those affected clauses if the contract includes a severability clause. The test of whether a clause is severable is an objective test, whether a reasonable person would see the contract standing even without the clauses.